You're listening to Wiley's Political Law Podcast, a series of podcasts on election law, ethics, and government investigations. In each podcast, attorneys at Wiley, a Washington, D.C. law firm, break down an aspect of the political law landscape with our unique insight into issues faced by our clients. Hello and welcome to the Political Law Podcast of the Wiley Law Firm. I'm Rob Walker. I'm of counsel in Wiley's Election Law and Government Ethics Practice Group. On today's episode of the Political Law Podcast, we're going to take a look at the transition team ethics plan that the Biden-Harris team has committed to putting in place if Democratic presidential candidate and former Vice President Joe Biden wins the election this November. And we are also going to review changes to government ethics and lobbying regulation that Joe Biden has pledged to put in place, or at least, or in part also to pursue if he is elected and there is a Biden administration come January 2021. I'm joined on this podcast episode by my colleague in Wiley's Election Law and Government Ethics Practice Group, Hannah Miller. Hannah, how are you? Hello.
I'm doing well, Rob. Thanks. Nice to be here.
Glad to have you on this topic. Let's get started. This is kind of a very information-packed episode here, so we have a fair amount of ground to cover. Let's get started talking about the Biden-Harris transition team ethics plan, and that was announced last week, September 30th, October 1st, and it was actually made public, required to be made public. Hannah, can you talk a little bit about the mechanism through which that transition team plan was made public and why it was made public?
Sure thing. So last year, Congress passed the Presidential Transition Enhancement Act, which was signed into law by President Trump in March of this year. The act amended the Presidential Transition Act of 1963 by clarifying the duties of the General Services Administration during presidential changeovers, and also requiring presidential candidates to publicly release ethics plans for their transitions before the election. So that's why the Biden campaign has released the Biden-Harris Transition Ethics Plan, which can be accessed on the gsa.gov website.
That's interesting and significant, and obviously it's the first such plan, or at least I believe it is the first such plan to be submitted and made public pursuant to that statutory scheme. So let me start by just talking about a couple of the provisions of the Biden-Harris transition team ethics plan that have to do, first, the kind of general approach to conflicts of interest in the plan. I should note that there is the transition team ethics plan, and as part of that plan, or at least together with that plan, there was public release of the Biden-Harris transition team code of ethical conduct that will be required to be signed by the members of and staff of the Biden-Harris transition team. So again, as I said, first to conflicts of interest, there is a kind of general statement in the ethics transition ethics plan that the transition team members will avoid both actual and apparent conflicts of interest, and that's easy to say. What does that mean according to the plan? That means that transition team members are not going to be permitted to participate in any particular transition team matter that they know may directly conflict with the financial interest of that member, an immediate family member, partner, client, or other individual or organization with which the transition team member has or has had a business relationship within the past 12 months. So that is the actual conflict of interest part. With respect to how the plan, transition team ethics plan, addresses apparent conflicts of interest, the plan goes on to say that even if there is no direct conflict, a team member will bring to the general counsel's attention, that's the general counsel of the transition team, obviously, any potential for the appearance of a conflict. And that phrase, appearance of a conflict, is historically a term that may have many meanings to many different people, but in the transition team plan itself, it is defined as existing, or an appearance of a conflict exists when the circumstances are such that a reasonable person would question the impartiality of a transition team member, or conclude that that member's work on a particular matter would undermine public confidence in the transition team. So that is the kind of general approach to conflicts of interest. There is a similar paragraph to what I was reading from in the Code of Ethical Conduct that has to be signed by transition team members. I think before I said it would be members and staff. Not clear down to what level these ethical requirements would go. I'm assuming they would apply. Member means staff. So I'm assuming it would be for all members and staff. In addition to that general kind of approach to conflicts of interest, the transition team ethics plan and the code of ethical conduct to be signed by the team members does have a lot of focus on use of and misuse of non-public information. In paragraph 3 of the transition team plan, such use, and it is a principle of the plan that the transition will safeguard non-public information, and that is defined with reference to the Presidential Transition Act, as well as safeguarding other information that is not readily available. And so the safeguards in place include that transition team members will be required to receive advanced authorization from the team's executive director or a suitable designee before even seeking access on behalf of the transition to any non-public information. And with respect to specific potential financial misuse of non-public information, the transition plan includes a provision that transition team members may not use such information either during or after the transition for personal or private gain for themselves or any other party. And specifically, it is also mentioned in the plan that transition team members, as well as their spouses and minor children, may not buy or sell individual stocks during their service with the transition unless they receive advance approval from the transition team general counsel. So there is a focus, or at least a provision in the plan relating to a kind of paralleling what is in place via the Stop Trading on Congressional Knowledge Act, which addresses insider trading by federal government officials. There is a kind of a paralleling statement and provision in the plan and in the Code of Ethical Conduct. So obviously, the plan and Code of Ethical Conduct for the Biden transition team also address service or potential service by lobbyists and foreign agents. And to talk about that, I'm going to ask you, Hannah, to talk about those provisions of the plan and of the Code of Ethical Conduct of the Biden transition team.
Sure thing. So the transition plan provides that any person who has engaged in federal lobbying in the last year, regardless of whether that person was registered as a lobbyist or not, And also, any person who plans to engage in federal lobbying in the next year can only serve on the transition team with the prior approval of the General Counsel. Further, with respect to registered federal lobbyists, those registered federal lobbyists are prohibited from contributing to, soliciting contributions from, or incurring any expenses on behalf of the transition effort. In addition, the General Counsel must also give prior approval to foreign nationals and anyone who has represented, aided, or advised a foreign government or foreign national, or rather foreign political party in the last year before such individuals can serve on the transition team.
The Biden-Harris transition team plan that has been filed, and that would come into effect if there is a Biden-Harris transition, includes revolving door provision, and that is provision that states that for 12 months following the transition team member's service, that member may not represent back to departments or agencies, may not represent back to them those departments or agencies on particular matters that that team member worked on during the transition, but also not just kind of after transition team service, but during transition team service, a team member will not be permitted to communicate with or appear before with the intent to influence any federal department or agency with respect to which that team member has substantial responsibility during the activities of the Biden-Harris transition team, unless they are doing so on behalf of a federal, state, local, or tribal government entity. And the transition team plan, the Biden-Harris transition team plan, also includes provisions addressing gifts and restrictions on gifts solicited or received by transition team members. And in this regard, I'm going to turn to the transition team code of ethical conduct, which kind of lays out the gift restrictions in a little more detail than the transition team plan itself. Paragraph 13 of the Code of Ethical Conduct to be signed by Biden-Harris transition team members provides, and I'll quote it, "Neither I nor any member of my immediate family will solicit or accept any money or thing of value as an inducement, reward, or thank you to influence in any way the Biden-Harris transition team's operations or decisions. This prohibition includes accepting a gift from anyone nominated for or seeking a federal job or appointment, or anyone advocating on behalf of such a person, any federal employee or person or organization that conducts activities regulated by or has a matter pending before an agency or department within the scope of Biden-Harris transition team responsibilities, or any person or organization under circumstances where the gift may reasonably appear to be given to influence or reward Biden-Harris transition team decision, advice, recommendations, or actions." Interestingly, this provision covers any money or thing of value, and in any of the circumstances that I have just described in quoting from the Code of Conduct. There's not a monetary threshold there or value threshold, and that is the gift provision. There are, before we turn our attention to the second topic, we have made reference in this discussion a couple of times, I think, to the role of the General Counsel for the transition team with respect to the Biden-Harris or enforcing and overseeing the Biden-Harris transition team ethics plan. And that General Counsel, who, according to the plan, will be responsible for enforcement, oversight, and compliance of the Biden-Harris transition team code of ethical conduct, is Jessica Hertz. She was, before going to the transition team, a director and associate general counsel on regulatory matters at Facebook. So let's talk now, and let's turn now to the proposed changes to government ethics and lobbying regulation that Vice President Biden has pledged to put in place or pursue if he is elected and if there is a Biden administration come January. The features of these changes are also described in a widely election law newsletter article that Hannah and I wrote for the September 2020 issue of the newsletter. And so let's talk first about the proposals that have been made in the Biden plan, so to speak, for lobbying reform to lobbying regulation. Hannah, can you talk about those a bit?
Of course. So the Biden campaign is proposing significant and broad changes to the current lobbying registration and disclosure scheme. Vice President Biden's legislative proposals include requiring elected officials to disclose all meetings and all communications with any lobbyist or special interest trying to influence the passage or defeat of a specific bill. Other proposals include requiring legislative and executive officials to disclose any bill or regulatory text submitted by an outside entity, and also a proposal requiring congressmen and senior executive branch officials to disclose access policies governing meeting requests. The Biden ethics platform also proposes legislation to lower the lobbyist registration threshold. This would include a requirement to register as a lobbyist for, quote, anyone who earns more than $1,000 annually to be involved in developing or overseeing a lobbying strategy, end quote. It's not clear whether or how this proposed $1,000 threshold is intended to replace the current registration threshold for those who actually engage in lobbying contacts with covered officials. At present, registration is required with respect to lobbying work for a client when a person makes more than one lobbying contact over any period of time for that client and spends 20% or more of their time for that client in any given 3-month period on lobbying activities. What is clear is that this proposed new $1,000 threshold would require registration and regular disclosure by so-called stealth lobbyists, or those persons who advise clients behind the scenes on developing lobbying strategy, but who do not themselves make any direct contacts or communications with covered government officials. Finally, the Biden platform also proposes legislation that would require lobbyists to disclose more details about their lobbying activity, including who they're meeting with, what materials they share, proposed legislative or regulatory language, and exact outcomes sought.
So those would be very significant changes in lobbying registration, disclosure, and regulation. And so it will be important to monitor and be on top of any such changes if there is a Biden administration. The Biden team's government ethics and lobbying regulation, I should say, kind of ethics reform platform planks, also include a proposal, and this is perhaps the most concrete and specific proposal in these areas, also includes a proposal to create a Commission on Federal Ethics, or CFE. And the purposes and powers of this Commission on Federal Ethics, as described by the Biden and Harris campaign, would be that this would be a body that would, quote, oversee and enforce federal anti-corruption and ethics laws, unquote. As proposed, this CFE would have broad investigative and civil enforcement authority. It would expand, as proposed, on the powers now held by the Federal Election Commission, the Executive Branch Office of Government Ethics, and the Office of Special Counsel. From an enforcement perspective, the CFE, it's important to note that the CFE would, as proposed, have authority to enforce its own subpoenas which would be a significant power, and would have the authority to refer matters for criminal investigation to the Department of Justice. And there would be a requirement that the CFE disclose publicly when DOJ chooses not to proceed with a matter that the CFE referred. From a disclosure and transparency to the public point of view, the Commission on Federal Ethics would be tasked with creating a centralized website providing a, quote, one-stop destination, unquote, where all federal campaign finance, financial disclosure, and lobbying information would be available to the public. Presumably, this would be financial disclosure information, not just relating to or involving executive branch officials, but also legislative branch and, I would imagine, judicial branch officials. The commission would also be tasked with, quote, tightening existing loopholes that let lobbyists cloak influence campaigns in vague disclosures, unquote. And one point not entirely clear to me in reading the discussions by the Biden-Harris campaign on this CFE, not entirely clear whether the CFE would simply be an originating agency for legislative proposals to tighten lobbying disclosure requirements, or whether the CFE would have some role in the oversight of lobbying registration itself, oversight that now resides in the legislative branch, at least in its initial stages. So obviously there is a lot that would have to be fleshed out about what exactly the structure, or I should say the purposes and powers of the CFE would be. The proposed structure of the CFE is notable, as proposed with a goal of, quote, avoiding the stalemate that afflicts some agencies, unquote, without naming what those agencies are. The CFE would comprise 5 commissioners appointed by the president, confirmed by the Senate, three of whom could be from the same political party, but no more than 3 of whom could be from that same party. But you can see then that there would be the ability for there to be a kind of controlling faction within the commission. It could be 3-2, would not be equal number of members proposed by each party. Nominees for this commission would be suggested by a panel of former prosecutors, judges, and state regulators. They would have to have experience in prosecuting public corruption or experience in regulating ethics and campaign finance. They would have a term, the commissioners, of 10 years, and they would be staggered terms. The commissioners could be removed only for cause. There's another level to the structure of this proposed Commission on Federal Ethics. The work of the CFE and its activities would also be monitored by an 11-member CFE oversight board, which would include bipartisan ethics, in ethics, campaign finance, and open government. And this oversight board would report to the commission twice each year with recommendations on how to strengthen ethics enforcement. And the CFE would be required to publicize recommendations made by this oversight board and provide explanations for any suggestions that the CFE determines not to follow. So that is the major proposal there. One other point to note with respect to the Biden-Harris lobbying and ethics reform platform and approach to those issues. There would, of course, be, according to the Biden-Harris campaign, an ethics pledge that senior officials of any Biden administration would be required to sign. And according to the Biden-Harris campaign, on day one, quote unquote, such a pledge would be issued. And according to the Biden-Harris campaign, it would build and improve on the Obama ethics pledge. Obviously, there have been ethics pledges for the past few administrations, and the extent to which any proposed Biden-Harris ethics pledge would differ from, and to use the language of the campaign itself, build and improve on past ethics pledges is unknown at this point. There has been no pledge issued and no specific provisions provided or discussed. That is something that would obviously be important to understand and to talk about, depending on the outcome of the election in November. And obviously, we at on the Wiley Political Law podcast and in the Wiley Election Law and Government Ethics Group will stay on top of any developments in these areas, as well as developments in campaign finance legislation that would also be a major focus of any Biden-Harris team. We'll stay on top of those, and if and as necessary, we'll talk about them with you in future episodes of this podcast. That's it for this episode of the Wiley Political Law Podcast. Thanks for listening. Thanks to Hannah Miller, my colleague in Wiley's Election Law and Government Ethics Practice Group, for joining me today.
Thanks, Rob, for having me.
Thank you for tuning in to the Wiley Political Law Podcast, brought to you by the attorneys at Wiley Ryan LLP. If you enjoyed this episode, we encourage you to follow us on SoundCloud. For additional resources and materials, head over to wiley.law. Thank you for listening. The views, information, or opinions expressed during episodes are solely those of the individuals involved and do not necessarily represent those of Wiley Ryan LLP and its employees. The material contained in this podcast is not intended to be and is not considered to be legal advice. Transmission is not intended to create, and receipt does not establish, an attorney-client relationship.